a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Indeed, you have got yourself a lawyer this morning, as always at this time on a Tuesday. David Whiting joins us in the studio. David, good morning.
Good morning, Ellie.
1300 222 774 is the number, but before we get to calls, David, I understand you had homework.
We had two lots of homework. The first one was imagine two houses with driveways next to each other. One driveway is higher than the other and the water flows down the driveway across to the caller's driveway and disappears under the house. And there's a provision in the Water Act relating to the interference with the natural flow of water. But the general presumption is that if you have a cause of action, a right to sue somebody, where there's a limitation period that applies. And what the caller said was that this had been going on for over 15 years. The question was, did the Limitation of Actions Act apply to claims under the Water Act? And my view is that it does. So I would probably be trying to have a discussion with your neighbour about whether it would be possible to perhaps put a lip on the edge of their driveway to
funnel it somewhere else,
or force it down the driveway into the street, which is where it's going to end up anyway. So that's the first one. The second one is, as a result of significant changes that have been made to the Residential Tenancies Act that came into effect last Monday, and was legislation introduced in 2018, so there was lots of press about it then. It was due to come in July last year, and they put it off until the 29th of March this year because of COVID and the effect that was having on everybody.
Is this the legislation that lets you have a dog?
Yes, right. Or tell me why the landlord has to justify not having the dog.
Yes, correct. Yeah. The onus of proof is on the other foot.
And there are a whole series of things that and this was Peter in Rowville who wanted to know about if his tenant decided to paint a room in the house, what happened at the end of the lease? Whose responsibility was it
to restore?
Well, the short answer is that it is the responsibility of the tenant to restore. Because there's a specific obligation to direct that the property be returned in the same condition that it was when you rented, fair wear and tear accepted. I mean, I can understand there might be a question as to whether, well, if I was allowed to do it, then doesn't that net the fair wear and tear? I think my preference would be that you've got to give it back as you received it.
So that would not just go to the colour of a wall, that would go to putting in nails to hang a picture, wouldn't it? There's
a whole series of modifications that the tenant can make, and the first group are you can make them without consent, and then the second group is a group where the landlord has to have a good reason for refusing consent. And, of course, the landlord can impose conditions where the consent is given.
But the general return the property in the state you found it in usually holds, doesn't it?
Yes, but specifically picture hooks or screws for wall mounts, shelves or brackets on surfaces other than brick walls, no consent required. Wall anchoring devices on surfaces other than bricks to secure items of furniture, no consent required.
But do you have to make good?
No, because I would, on my view of the legislation, no.
I can see a case in the residential tenancy.
Oh no, I think there's going to be lots of cases as to when I've got to give it back to you as I found it. What exactly does that mean? So,
we wait with interest. I'm sure there's going to be more.
It'll take 12 or 18 months to get there.
It will, and there'll be many questions for you in the interim, I have no doubt. Okay, 1300 222 774. David in Ringwood, kick us off this morning. Good morning.
Good morning to you.
Hello, David.
Morning. My question... Oh, sorry. I'm wanting to make a claim for $17,000 in relation to a roofing job that was done. And given the amount, I was wondering whether it's better to go through VCAT or get a solicitor and go straight to court.
David, the reason that you would use a solicitor, I don't want to go there. I would be inclined to go to VCAT.
Right.
Because if you were to lose, there's going to be no order for costs made against you.
Right.
If you were to go off to the magistrates' court for your $17,000 and you were unsuccessful, there could be a costs order made against you. Now, what I sometimes recommend to people is that they engage a lawyer for an hour or two for the purpose of working through what evidence they will need and how the case ought to be presented.
Right.
Now, you won't get those costs back if you're successful, and if you're not successful, you're not going to get them back anyway. So you can go along and tell your story, and you're either believed or not believed, you're either accepted or not accepted. So what I would be inclined to look at VCAT because of the reduced risk.
Yeah, I was just wondering about delays.
I think delays would be less at VCAT than in the magistrates' court.
I would have thought so, just particularly given post-COVID, what's happening in our court system at the moment. It's
Well, if you think about it, for lots of people, VCAT is a court. It's technically not, but to all intents and purposes, it adjudicates people's rights.
Do they have the same backlog that the court system does?
I haven't looked recently. I think their backlog would tend to be less.
Molly in Epping. Good morning, Molly.
Yes, good morning. Look, last year we were surprised to find that, unbeknownst to us, we didn't have a vote because our whole council and mayor had been sacked by the Labor government and replaced by administrator and 2 people, so 3 people running the joint.
Yes.
Now, how do we stand in a democracy? This sounds more like a dictatorship. Who represents us now, and how do we have a say in what happens in the council, in the area?
I don't know how things are operating in Whittlesea at the moment, but I do know that similar things have happened in lots of councils over time where there's been a concern about the administration of council, and the Minister for Local Government then comes along and says...
A certain amount of corruption?
Well, I do not know the underlying facts in the Whittlesea, and I don't think it's fair to speculate as to what they might be.
How do I find out?
Well, there will be a government gazette that will have reported the appointment of the administrators.
And numerous media reports too, might I say, about Whittlesea.
Now, the other thing, Molly, is that what usually happens is that the administrators conduct council meetings in the same way as council did. Now, I don't know whether they're doing that at Whittlesea, but I had a bit to do with Melton some years ago, and there were formal council meetings that were conducted as a council meeting where the administrators did the business of council.
So Molly could still go and
if they have those meetings, she could still do that.
Heard.
And
what
there will still
if they don't?
Well, they will still publish their agenda. They will still publish their results of their resolutions. And what you might do is ask the Minister for Local Government when it's anticipated that there will be elections in Whittlesea.
Right, yes, I'm very anxious to find that out.
Look, Molly, it's an interesting point you raised. I don't know, David, this has obviously been a question without notice, but do you have any memory of how long, when councils are sacked, it does seem to happen more often than not, how long it takes for elections to be held? Because sometimes those administrators sit in place for quite a while.
2 to 3 years is my guess as to what an average period would be.
It's quite a long time.
Yes, it is. It is.
But maybe they have big jobs to sort things out. Sharon in Croydon. Good morning, Sharon.
Good morning. The nub of my query is my elderly mother had a fall and has now gone to live with one of my sisters. And so her unit is sort of vacant at the moment. And one sister wanted to sell the unit and divide the money now, prior to my mother passing, and pay the tax or whatever. Another sister is very reticent about contacting Centrelink to find out or involving them. And I just want to find out where we can go to get all the facts, listed.
Let's back up a little. What you've got to do is decide whether your mother has absolutely no prospect of moving back into the unit or not. So if your mother was, and I'm not trying to put words into your mouth, but if your mother was at your sister's place for rehabilitation and within a reasonable period of time, that having regard to your mother's age might be 6 or 12 months, that she was planning to move back into the unit, then as far as I'm concerned, that's still her principal place of residence. Right. She's at your sister's for a reasonable period of time, but she hasn't moved there permanently.
Yes.
If your mother, on the other hand, has decided that she is not going to move back to the unit, either because she likes living with your sister so much or she can't,
yes,
then you have an obligation to tell Centrelink that you have left the property permanently, and her pension entitlement will be adjusted on the basis of her changed asset position. Right? She will no longer be living in her home. Right?
Yeah.
Now, the third issue is if the property was to be... So from your mother's point of view, if the property was sold, it makes no difference. We just know precisely how much it is rather than speculating about a valuation. So it's the same asset.
Yes.
But if your mother then decided that it was appropriate to pass on the inheritance ahead of time, then your mother would lose her pension.
Right.
Because the assumption is that we are primarily responsible to look after ourselves.
Uh-huh.
And so what the law says is that if your mother was to give away, I think it's more than $30,000 over 2 years, but you should check, then what the excess that she gives away will still be included as an asset of hers for 5 years. So let's say she sells the unit for $400,000 and she gives each of you 100, then the law would say she's still got the 400.
Oh,
But she's given away more than she was entitled to.
Ah, yes.
So you then, and you might come along and say, well, would Mum be better off if we kept the unit and rented it?
Yes.
Now, that to me involves an assessment of your mother's health, her age, so we could then make some attempt at assessing her longevity. So they're the kinds of things that you look at. But I can tell you, if you sold it and divvied up the proceeds, even if it was your mother doing the divvying up rather than the children, that would have adverse Centrelink consequences.
Right, yes.
And so your first question is this a permanent exit move?
Yes.
All right? And when you've worked that out, you then look at what the consequences are from that.
All right.
Sharon, lots of questions for you and the family. Glenn in Yarraville. Hi, Glenn.
Oh, hi, David. Look, my question is, I'd like to know what might be the legal risk to an owner's corporation if a vendor in a unit development in selling their property has failed to mention termite treatment to common property areas. Termite treatment being under an ongoing contract with a termite treatment company.
So this is a question about someone who is selling a unit. Is the existence of the termites... When you sell a unit, you are required to include certain information under Section 151 of the Owners Corporation Act. That includes the financial statements for the Owners Corporation and the last annual general meeting minutes.
Yep.
If the existence of the termite contract is disclosed in the minutes, then my view is that you've probably fulfilled your obligation.
Well, it wasn't.
Well, is that a failing of the Owners Corporation?
Isn't the owner meant to sign off on the Section 32?
There's two answers to your question. I'm a lawyer. There's always two answers, Glenn. The first is that under Section 12 of the Sale of Land Act, there's a requirement that a seller provide all material information to a buyer. Now, that is information, I describe it to my clients about what would you like to have known about the property in the neighbourhood before you signed the contract that wasn't in the documents. So there's only been one case, and that's on an equivalent New South Wales provision, and so you would want to know if somebody had been murdered in your property. Yeah, it might not be material if somebody died there, but if someone were murdered there, then I think that's something that I would like to know. So there might be an argument. The problem with it is, though, Glenn, is that Section 12 doesn't actually provide any benefit to the buyer of the property. It just makes the person who doesn't provide the material information liable to a penalty for an offence.
Right.
So I would then go along and say, would it be usual if is the unit in Yarraville or thereabouts?
Yeah.
Is it an area which is known for termites?
No.
Is it a place where one would expect there to be termites?
No, it's not listed under the council.
Wasn't on the land information statement from council.
No.
All right. Then I suppose your next problem is what's your loss? And I would come along
Is it misrepresentation?
Yes, but we're now talking about what's your damages.
Mm.
And we're currently in a rising property market.
Mm.
Are you telling me that if you were to sell the property again, you wouldn't get your money back plus a bit more?
No, I'm talking about the risk to the owners' corporation. I'm a member of the owners' corporation. One of the owners has sold the property.
Yes.
Without disclosing this information in the Section 32.
From the owners' corporation, I would be asking why was it not a matter that was referred to in the owners' corporation minutes?
Well, it was decided basically at a extraordinary meeting that was never minuted.
That the termite work would be undertaken? Is it
Correct.
since or post the annual general meeting?
Post the annual general meeting.
I would have liked to have thought that the owners' corporation manager who's paying the bills would have in fact brought this to attention of somebody.
Mm.
So
Bottom line, there's not a lot that Glenn can do at this point.
Well, no, Glenn is speaking on behalf of the owners' corporation. He says, well, what do we do that we've done what we're required to do? I suppose my initial reaction, Glenn, without reading the Act in its entirety, would be to say that it's a factor that's material from a buy. Well, it may or may not be material.
Is it not an obligation on the vendor to ensure the accuracy of the Section 32?
You haven't told me anything that would indicate that the vendor's statement, the Section 32, is inaccurate. All right? It's a question of disclosure under Section 12.
Yep. Glenn, thank you. I'm going to leave that one with you. Terry in Nagambie. Hi, Terry.
Good morning to both. David, I'm just wondering how myself and my partner protect each other on the property that we own between us for our children. In other words, if I was to go first, how do my kids get protection on the property or vice versa?
Are they the children of you and your partner, Terry, or children from previous partners?
No, well, my partner has 3 and I have 2.
Yes.
And so if my theory is, if for arguments in my mind, is if I go first, the house is automatically hers. So therefore, she doesn't have to do anything or vice versa.
Terry, what if you're looking for a guarantee? There isn't one. Just get divorced, do a property settlement, hand the money on, right?
Right.
What I tend to do in those circumstances is get the parties to sign an agreement about how they will leave their estate.
Okay.
If you think about a will, it's your document. It's not your partner's document. It's yours, right?
Yep.
And your partner's will is your partner's will. It's not yours. So what happens is that Terry says, if you promise to make a will like this, I'll make a will that basically says the same thing.
Okay.
And I promise that if you die, I will make sure that I always have a will that makes the same kind of provision. Right. And I will make sure that while I'm still entitled to draw on money to meet my living expenses, I won't deliberately diminish my estate for the purpose of causing your kids to lose out. So it's an agreement to make mutual wills. The intention is that you're creating what amounts to some kind of trust that's to benefit all of the children in your agreed proportions.
Okay.
There you are.
Thank you very much for that information.
Good luck, Terry. I tell you what, and even when you do that, though, it doesn't necessarily mean it's set in stone, does it?
No. The only way you can make sure of that is both go at the same time.
Ah, yes.
It's a bit tricky.
Mark in Taylor's Lake. Good morning, Mark.
How are you? David, the old question of the neighbours' trees hanging over the fence.
Yes.
Which, for quite a few years I've cut to the fence perimeter and happy to get rid of them. But the trees have grown quite large, and they're very tall now, so I have to buy some equipment. I mean, I've got a quote. It's more than $1,000 to get someone else to do it.
Yes.
If I ask the neighbour to do it, and he doesn't do it, where do I stand, or what are my options?
Oh, your
Other
options
than
are
keep doing it myself?
Your options are to go to the magistrates' court for an order that your neighbour get his. If you've got to be thorough about this, Mark, go for the roots, just not the branches. So your argument would be, I want you to put in a root barrier because I want you to get your roots off my property, and I want you to make sure that your branches do not encroach.
So that's interesting. I had understood that it was actually the responsibility of the neighbour, as in...
It's the tree owner.
It's the tree owner?
Yes. So if you had a house next to me and you had a very nice tree that wanted to extend to the sunlight in my property, that's your problem. You have no right to have your tree grow over my property.
I thought that the neighbour has the complete ability to chop it, not to damage the tree, but to prune it.
There are some issues in some local laws if it might be a heritage tree or a tree around which there are some restrictions, but I would have the right, in the example I gave you, to cut your branches back, provided I didn't go beyond the fence line, and throw them over the fence onto your property. I can do all of those things, but that's a right to exercise self-help. It doesn't shift the obligations of the owner of the tree. It sort of takes them away.
Yeah, okay. Right? I think a few councils don't have that specific advice on their website, from my experience.
No. Well, look, you're allowed
slightly fudged, maybe.
Well, it depends on the size of the tree and the amount of effort that's involved. I can remember being involved peripherally on a property in Camberwell that had 5 or 6 huge pine trees. And there were needles and dropping branches and all sorts of things. And the neighbour next door said with some justification, what if they get old and they're currently old? What if they fall over? So there are steel trusses, there are all sorts of things to make sure that that becomes less likely. But the owner of the tree has the responsibility for the tree.
Okay. Let's just finish with Gurm in Bundoora. This is a fascinating one. Hi, Gurm.
Hello. I attend quiz nights as a hobby and pub quiz nights, and they often issue prizes in the form of vouchers, like it might be a $50 voucher. What I find, though, is that by the time the competition's finished, they've closed off the tills in that particular bar, so you can't use the voucher on that night. And then often the vouchers expire within a week or maybe 2 weeks, and you're not back within a week or 2 weeks. I was wondering how this fits in with that.
You don't sound like a very good... I don't want you coming to my pub, Gurm.
Well, we don't always win, but we did actually win a lot of prizes before COVID.
Yes.
And I understand how they're all void because of the circumstances.
Yep.
But I'm wondering how this fits in with the idea of gift cards and vouchers, and is prize money different from gift cards?
Interesting question.
Look, it might be... it's a prize, not a gift card. So a gift card is issued at the request of a movie chain or a hardware store or a hi-fi store, and they are required to have a particular minimum expiry date. But you pay for them. You haven't paid for the prize.
No.
So they won't be bound by the same law or code of conduct. And I suppose my question would be, if you were coming to a trivia night at my pub, don't own one, but if you take mine, and the tills close at 10 and the competition closes at 10:30, I would come along and say that would be really unreasonable, and I would be talking to the promoter of the trivia night and making a complaint to them.
That's what I'd be doing, Gurm. I'd be getting your mates together and going down to the pub and saying, we're not going to participate anymore unless you make the prizes a little bit more palatable for
But we
all of
are
us.
going to sit in the middle of the area where you're doing the quiz.
Yes.
We're just not going to
and make
participate.
a lot of noise, but not participate. Thank you to everyone who participated today, and to David Whiting yet again. Nice to see you.
Thanks, Ali.
David Whiting there, Melbourne solicitor, who'll be back next Tuesday to take your calls.